millions I see, and people are recognizing us at FedSoc events and stuff. But we have some interesting Supreme Court news this week. First and foremost, we have a new grant that was announced this morning in the order list. We also have four cases that will be argued this week. So, without further ado, Mr. Dunford, what case got granted this morning?
This morning, the court granted cert in Watson versus the Republican National Committee. The Watson is the Secretary of State of Mississippi, and the question before the court involves when you can count certain ballots. So under federal law, the Tuesday after the first Monday of November is the election day for federal offices. And Mississippi requires that ballots for federal office be cast by that day, but the statute also allows some timely cast ballots, like mail-in absentee ballots, to be counted after Election Day. And the Fifth Circuit held that that all of these all of these ballots must be counted by Election Day. And so the question is whether the federal law preempts the state law. And among others, the Republican National Committee opposes the argument, and here the RNC is represented by our friends at Consovoy McCarthy, and they say that federal law is federal law, and that it should preempt Mississippi, and they point out that states have extended these deadlines further and further. So I'm not sure they necessarily oppose the couple days that the Mississippi has here, but I think in general the RNC is opposed to the continuing extension of the counting of ballots after Election Day. So they got today, and I don't know when it'll be heard. Sorry.
So the argument is that the Constitution requires all ballots to be counted by the Tuesday?
No, there's two statutes that set
Okay.
the deadline, the election day for federal offices. And so whether all the ballots have to be counted on election day, quote unquote election, close quote, day.
So why wouldn't that be preempted?
I think because there's nothing express in the federal statutes that say when they have to be counted.
I see.
And so states do have some authority for running elections. And so the question here is, I suppose, the difference between how a state carries out the elections, even for federal offices, as opposed to the other things that Congress has specifically codified.
And I think earlier in the term, one of the first two cases that was argued was that standing case, if you remember, of the sitting senator who didn't want ballots counted in his election after. So it seems like it's a similar issue, even though that one was on standing, but it's ultimately the same issue that's involved, right?
Yeah, that's right. That's a good point. And usually, well, that's a good point. I was going to say they usually try to time the oral arguments up, but if this one was just granted, then I wonder if they'll hold that opinion. There's still time, I assume, to hear this case, this term. So maybe they'll hold the case you mentioned before and issue the opinions close together.
And so it's the state of Mississippi against the Republican Party?
Yeah, there's some other parties involved, but yes, it's
interesting.
Yeah.
Well, it'll be a fun one to watch as those parties line up. The first case argued today deals with the intersection of RLUIPA and RFRA and the Constitution. The case is called Landor versus Louisiana Department of Corrections. So this is a case where the facts are egregious and hold on, Larry thinks I'm coming, but he doesn't know that I'm on vacation today, so I'm not coming to the meeting. So this is a set of egregious facts where there's a Louisiana prisoner, who, as a Rastafarian, had dreadlocks that was consistent with his religion for, I read 15 years, something significant. And there was existing Fifth Circuit precedent that said you could not cut his locks because that would be a violation of federal law. He had the opinion in hand as he went to the prisoner officials, and they said, "We don't give a shit," took the opinion that he handed them, threw it in the garbage, and proceeded to shave his head. So he brought suit against the Louisiana Department of Corrections for a violation of the religious land use, RLUIPA, which stands for, do you know what RLUIPA stands for?
Religious liberties.
Already wrong.
Protector.
Religious Land Use and Institutionalized Persons Act. So this is, if you remember the history behind this, this is Employment Division versus Smith holds that general statutes of general applicability can be enforced despite religious objections. Congress passes RFRA, and then City of Bernie, I believe the court holds RFRA unconstitutional as it applies to the states. Then Congress passes RLUIPA, which is what we're dealing with now. So RLUIPA holds that you need a compelling interest, and it must be a narrowly tailored means to affront someone's religious liberties. But the question in this case is, can you bring an action for damages under RLUIPA? Now, the Fifth Circuit held that you can't, based on universal precedent among the circuit courts that said, no, it's only injunctive relief and declaratory relief. They petitioned the Supreme Court for review of that decision. Now, in 2020, the Supreme Court held in a different decision that RFRA, which has identical language to RLUIPA, does allow for damages against federal officials. So the argument is if the language is the same, why wouldn't this one be the same? And I wanted to read the QP that the petitioners got granted here, because I thought it was pretty good and a pretty good example of what to do. Congress has enacted two sister statutes to protect religious exercise, RFRA, RLUIPA. In Tanzan, that's that 2020 decision, this court held that an individual may sue a government official in his individual capacity for damages for violations of RFRA. RLUIPA's relevant language is identical. The question presented is whether an individual may sue a government official under RLUIPA. So just pointing out to the court that there's no different in text. Why would there be a difference in outcome? It's a pretty powerful statement. Now, what the other side has going for it is decades of precedent. They also make a pretty interesting spending clause defense where the states are accepted. The only reason RLUIPA applies to the states is through the spending clause, because you couldn't do it through the 14th Amendment, like City of Bernie said. So there's a spending clause issue there where if the states are being compelled to act contrary, it's sort of like a South Dakota versus Dole issue. So that's all tied up in their defense of why they can cut off the guy's hair. And they're saying essentially we can't be compelled to do this, and if you compel us to do this, then RFRA is unconstitutional under the spending clause. I think the problem that they have is the textual argument is pretty forceful, and their spending clause argument requires them to sort of declare one part of the statute unconstitutional in order to get it. It's pretty convoluted, and they're pointing in a bunch of different directions. It seems like not something the court would want to do. I would also add that egregious facts like this, if you can't get injunctive relief because it's already happened, and how are you going to get injunctive relief in the future? And that's kind of the moral force of the petitioner's argument. If we don't have damages, then these state officials are just going to thumb their nose at the court going forward. The guy brought the opinion in hand to them, and they still said, go screw yourself. So all of that, I think, seems likely that the petitioners are going to win in this case, but it's an interesting one.
Did he not bring a 1983 claim? Do you know? That's
a good question. I don't believe he did bring a 1983 claim, and then the question would be, why didn't you bring a 1983 claim, right?
Yeah.
Yeah. Probably have to dig into the facts a little bit more.
Yeah,
I'm sure there's a reason, but
right. I was going to say there's got to be a reason it's not up here.
Yeah. We'll get back to you after we've heard the oral argument later in the week when we've had a chance to do a recap. But that's a very good question. The second petition today, or the second case being argued today, is called Geo Group versus Menocall. And this case deals with, it was similar to a case that we heard last week, the government contractor that dealt with the explosion in Afghanistan and whether they could be held liable for torts in state court. Yeah, in South Carolina State Court. This case deals with a contractor that was contracted to build and maintain ice facilities in Colorado, private contractor, and they seek something that's called, I forget what the precise name is, but it's like general contractor derivative immunity from suit. So they're saying because they're sort of acting in a federal capacity that they should be immune from suit. The district court held no. They sought interlocutory appeal of that on the grounds that under some immunity doctrines like qualified immunity or sovereign immunity, you can seek interlocutory relief. And as sort of standing in the government's position in this case, they ought to also be able to seek interlocutory relief. The 10th Circuit held that they could not. So the question presented is whether this immunity doctrine allows for interlocutory relief. I think the argument for the petitioners here is they are standing in the petition of the government. The reason you allow for interlocutory appeals of these immunity doctrines is because immunity doctrines are supposed to prevent you from engaging in discovery and all the costly litigation things. And if you can't appeal those in an interlocutory fashion, then it sort of defeats the purpose of having those immunities. So they're saying if we have to go through the whole rigmarole of litigation, then why even have this immunity doctrine in the first place? The argument for the other side is, those immunity doctrines are constitutional immunity doctrines. They are there to protect the purse and official governments. This is kind of a made-up immunity doctrine that you only get by virtue of you working with the government, but you yourself are not the government. So you can get relief at the end of this case if your immunity defense wins, but it doesn't have the same power of the purse problems or hauling government officials before the court problems that other immunity doctrines do. Interestingly here, the United States has lined up, unlike our previous case, they have lined up with the respondent here, saying that they should not get interlocutory appeal rights for asserting this immunity, and their sort of interests can be resolved at the end of the lawsuit. So in the previous South Carolina case, the government lined up with the private contractor, but here they are not. So we'll see what happens. A lot of these jurisdictional cases are some pretty interesting ones that have been before the court recently.
Yeah, and bringing up some immunity doctrines, especially in the last case. It doesn't sound like it's being brought up, but one of the questions about qualified immunity is how far it should go, or if it should be pared back. And the one seems to be there's some consensus that if it's going to change, policemen and firemen who are making split-second decisions perhaps should be immune. But in this case, you point out the prisoner brought a copy of the case saying.
Well, it's a different case. We're the
government. I'm saying, but in that first case, but in that case, so the prison guards knew, or should have known that it was illegal, and so it's not a split-second decision. This is obviously different, but it's another question about how far the government's immunity from suit can go. Agreed.
I'm reminded, brief story time, when we were at the FedSoc National Lawyers Convention last week, and I think it was Justice Kavanaugh was up there saying, when you're sitting as a Supreme Court justice, you got to be amenable to criticism. When we're out there saying, or maybe it was the Justice Oldham on the 11th Circuit, when he did his speech on Friday, Fifth Circuit. He said one of the judges or justices said something to the effect of, when we're out there holding that you can't stop people from attending church during COVID, you're cheering us, and when we say something about qualified immunity, you're all booing us, and the crowd there sort of took him up on those opportunities to boo and cheer. So we'll see what happens with these immunity cases. Obviously, we have some interest in paring back qualified immunity here at PLF, especially insofar as it deals with non-split second decisions, as you point out. But those are the cases being heard today. We'll be back later in the week with see how those arguments shook out, and we'll have some answers to those factual questions that you've had. But what cases are being heard on Wednesday?
On Wednesday, 2 cases, and they both involve a statute that allows district courts to reduce sentences for federal convicts, and they are allowed to do so in extraordinary or for extraordinary and compelling reasons. And that's true in both cases. And the statute does say one other thing about that, and it says that the reason for the reduction has to be more than mere rehabilitation for the defendant. So if there are extraordinary and compelling reasons, except or in addition to the rehabilitation of the defendant, the sentence may be reduced. So the one case is Fernandez versus the United States. The other case is Rutherford for the United States. In Fernandez, the first case, the petitioner is relying in part on considerations that apply in the United States habeas corpus statute. And the question is whether a district court can consider those reasons or whether those reasons are separate from the consideration of the compelling and extraordinary and compelling circumstances. And according to the government, they are the reasons in the habeas statute are neither extraordinary nor compelling. Habeas petitions are filed all the time; they're extremely common, and there's nothing compelling. And they pointed out that the petitioner in this case was validly convicted for shooting 2 men to death, and now the government asserts he's simply trying to repackage his complaints about the initial sentence and his habeas petitions through this new sentence reduction statute. In the second case, Rutherford, the argument or the circumstance that brings rise to this case is that after Rutherford was convicted and sentenced, Congress changed the sentencing laws and reduced the amount of the sentence for the same conviction that this guy had. And
what did he do?
He also shot. It was an armed robbery, I believed. Yeah, armed robbery. And his argument is that there's a lot of disparity now, and therefore one of the things that the district court should be able to consider in reducing the sentence is whether the disparity between those who are convicted after the 2018 law went into effect and those who were convicted under the previous regime is a sufficiently extraordinary and compelling. According to the United States, the statute in question, the 2018 statute, which reduced the sentences, did not expressly provide that it would apply retroactively. And so generally speaking, if Congress does not say so, laws apply prospectively only. In both cases, the circuit courts ruled against the petitioners, obviously, and so we'll see what the court does with these 2 decisions and whether they want to give any more wiggle room, I guess. The problem I see for the petitioners, though, is that the statute says that district courts have consideration for compelling, extraordinary reasons, and they're looking at other statutes to provide those reasons. And there's some intuitive force to it, but it seems like if Congress wanted to make it easier, that they could have done so. And I suspect, especially with Alito and Thomas and others on the court, that the petitioners are going to have a difficult time. But they did accept both cases. So
yeah, I mean, like the fact that the statute changed and the same offense would be sentenced differently, that does sound. I mean, I grant you that it's not doesn't say it's retroactive and it's expressly, but it does sound like an extraordinary circumstance.
Yeah, and in both cases, to side with the petitioners here a little bit, the question really is not the ultimate answer. They're not asking the court to say that the sentences should be reduced.
Right.
The petitioners merely asking the Supreme Court to say that the district courts may consider these other factors when they decide whether to reduce the sentence.
Yeah. Yeah. Right. Maybe that's a way for the court to rule for the petitioner and not really. I mean, yeah, because it doesn't mean the court has to find there's extraordinary circumstances, right?
Right.
Interesting. Okay. Well, short and sweet. Anything else for our listeners, Oliver?
Nothing.
Well, thank you for joining me. I'm in the great state of Wisconsin here in my brother's basement, and there's snow on the ground, so it's lovely. And where are you? You're in.
I'm back in the swamp.
Which is Florida, not DC.
It was 87 degrees yesterday when I landed. It's supposed to be 60s tomorrow, and it's going to be in the 40s for about 20 minutes tomorrow, and people are freaking out.
Sounds lovely.
Yeah.
All right. Well, we'll be back later this week for a recap of this week's oral arguments. Thank you again for joining us on the PLF Supreme Court show. Talk to you soon.